नमस्कार, नमस्ते, नमस्कारम, जय श्री राम। देखो इसके लिए क्लास नहीं है। Government did not want to elevate him to Supreme Court. Why? Because he declares president's rule unconstitutional. अब वो कैसे होता है? इतना सारा मान लो थोड़ा थोड़ा हम गलत बोल सकते हैं। आज के लिए फ्रीडम है, मतलब क्या बोलते हैं उधर उत्तर प्रदेश में, गंदा नाच। सॉरी टू से दैट। अपॉइंटमेंट में गंदा नाच होता है। सॉरी टू से दैट। वो कैसे होता है ये देखो, ऐसे होता है। We were talking about collegium system, right? And positives of collegium system we were talking, that the advantages. So let's take what happened. That's why we told you to remember the name K.M. Joseph. आगे काम आएगा, वो टाइम आ गया है, right? See, judges do not have ulterior motive. वो नहीं कि रिटायरमेंट के बाद उसको अपना कंपनी बनाना है, ठीक है, या उसको अपना एनजीओ खोलना है, या पॉलिटिकल पार्टी स्टैब्लिश करना है, या वो पैरेलल एक कॉन्स्टिट्यूशन बनाएगा। ऐसा कोई उसका अल्टेरियर मोटिव नहीं है। दिस यू हैव टू अंडरस्टैंड। एंड जजेज आर नॉट सपोज टू गिव ए फेवरेबल जजमेंट। तो फिर जजेज की जरूरत क्या है? अब कंगारू कोर्ट को ओपन कर लो फिर। Why there should be this judiciary, right? If judges want to give favorable judgment, तो फिर तो कोई बात ही नहीं है, क्या जरूरत है उसकी? So those judges who give judgment on the basis of जो भी उनका judgment है, right? That judgment, let's say कि what you can say, उत्तराखंड, तो उत्तराखंड KM Joseph was Chief Justice, and let's say कि he was elevated to Supreme Court. So Supreme Court collegium elevated him. Then let's say कि government junked him. Government did not want to elevate him to Supreme Court. Why? Because he declares president's rule unconstitutional. अब वो कैसे होता है? इतना सारा मान लो थोड़ा थोड़ा हम गलत बोल सकते हैं। आज के लिए फ्रीडम है, मतलब क्या बोलते हैं उधर उत्तर प्रदेश में, गंदा नाच। सॉरी टू से दैट। अपॉइंटमेंट में गंदा नाच होता है। सॉरी टू से दैट। वो कैसे होता है ये देखो, ऐसे होता है। तो बेसिकली लेट्स से वी हैव collegium. Collegium, we have Ministry of Law and Justice, PM, President. Collegium will send name to Ministry of Law and Justice. Ministry of Law and Justice, if it wants that for reconsideration, it can send one for reconsideration. This. But if it again sends second time, it is binding. This. Then let's say that once it approves, so basically Prime Minister means Council of Minister, right, advises President and judges are appointed. Now, when they send collegium, let's say that when it sends names, तो उसका नंबरिंग होता है, राइट? तो वो मान लो कि 3 लोगों को सेंड कर रहे हैं, देयर आर 3 पर्सन्स A, B, C, तो वो ऑर्डर में सेंड करेंगे, राइट? तो मान लो उनका ऑर्डर है CBA 1, 2, 3. So the date of appointment, the time of appointment in the Supreme Court and High Court decides your seniority, not the past background, how old you are, how long you have served, it does not. So the day you are appointed, now he is appointed first, he will be senior to them. If C is appointed first in the order, so C is senior to B and A, even if they have been appointed on the same day, same time. This, and then B would be senior to A. This. So judiciary sends in order, right? Now, what it does, एग्जीक्यूटिव क्या करेगी? मान लो एग्जीक्यूटिव को बी को अपॉइंट नहीं करना है, राइट? बी को अपॉइंट नहीं करना है और सी और ए को करना है, तो ये क्या करेगी जुडिशरी? इसको रिकमेंड करेगी बैक, वो लिखेंगे ए, सी एंड बी, चेंज कर देंगे, राइट? और वो क्या करेंगे कि सी को अपॉइंट कर दिया, ए को अपॉइंट कर दिया, बी को छोड़ दिया, दिस. सो दे विल चेंज इट. और मान लो उनको तीनों को नहीं अपॉइंट करना है, तो वो कुछ भी नहीं बोलेंगे, राइट? मीनवाइल इन्होंने कुछ और नाम भेजा है, उसको फॉरवर्ड कर देगा. तो जिसको नहीं अपॉइंट करना है उसको डक्ट कर देंगे दिस लिस्ट से, और जिसको अपॉइंट करना है दे विल अगेन फॉरवर्ड टू जुडिशरी फॉर रिकंसिडरेशन, और दे विल सेंड दिस नेम फॉर रिकंसिडरेशन, और सी और ए को अपॉइंट कर देंगे. तो सी और ए को अपॉइंट कर दिया तो ए सीनियर हो गया बी से, दिस, और बी को अपॉइंट नहीं करना चाहते, दिस. दैट इज हाउ इट हैपेंस. नाउ लेट्स से केएम जोसेफ के साथ क्या होता है. He was senior most at 34th position. At all India level, he was that time senior most at 34th position. Right. So he was elevated because judiciary considers him as a competent judge. So he was elevated. जब elevation किया गया तो गवर्नमेंट ने बोला कि we prefer merit not seniority. Sorry, we prefer seniority not merit. मेरिट और सीनियरिटी में सूटेबिलिटी देखते हैं. जब आप मेरिट पे रेकमेंड करोगे तो वो बोलेंगे सीनियरिटी होना चाहिए, अब सीनियरिटी रेकमेंड करोगे तो बोलेगा मेरिट होना चाहिए, दिस. तो केएम जोसेफ वाज एलिवेटेड ऑन द क्राइटेरिया ऑफ मेरिट, बट गवर्नमेंट साइटेड कि नो देयर शुड बी सीनियरिटी, ही इज नॉट ए सीनियर मोस्ट, हेंस हिज नेम वाज जंक्ड इन द ऑर्डर and government delayed it and other judges were appointed. Now judiciary persisted with his name. This judiciary persisted with his name. The second time again his name is recommended. Now second time when it recommends, it is binding. Now government changes his order. Right. And order is changed in such a way that he should never become Chief Justice. This you should know. So they will delay, they will see how long he will be judge, that they will try to delay it so that he cannot become Chief Justice. Then they will change the order so that he should not reach to the Chief Justice, because he should not become senior most judge in Supreme Court. तो ये that is how I was saying कि गंदी नाच, sorry to say that, मेरे लैंग्वेज में ऐसे ही होता है. Right. Such a menial level of things they go into permutation combination. किसको चीफ जस्टिस बनाना है, किसको चीफ जस्टिस नहीं बनाना है, राइट? ऑन द वन हैंड हम मुखौटा है हमारे पास कि हम मेरिट प्रमोट करते हैं, इनोवेशन हम प्रमोट करते हैं, कॉम्पिटेंस हम प्रमोट करते हैं, और दूसरे तरफ हम उसकी, राइट, हरियाणा के लैंग्वेज में माँ बहन करते हैं, यूपी से हरियाणा. Anyhow, sorry to say this language, but I will not speak more than that. No. We'll come to this. It's not like that. Now, what happens? KM Joseph second time ही जब recommend कर दिया गया तो government was not appointed. Deepak Mishra was Chief Justice. He offered to resign. He told, if you would not appoint KM Joseph, I am resigning. This. Then government appointed KM Joseph. Problem क्या था? Why you are not appointing? Right. Because he declared one president's rule as अनकॉन्स्टिट्यूशनल। और आप बोलोगे कि नहीं उसके वजह से नहीं, तो ठीक है दूसरा केस लेते हैं फिर। हर केस में कोइंसिडेंस तो नहीं हो सकता है। दिस एंड इट इज द सेम केम जोसेफ, you know that, who have given judgment of election commission. That election commission members should be appointed by selection committee. It is the same KM Joseph, right, who saved N. Ram. You should know that. Government invoked official secret act against N. Ram for publication of 8 articles on Rafael deal. KM Joseph was part of that bench. He told to Attorney General, it is settled matter, please don't bring again. Right. Settled matter is कि RTI has overriding power on official secret act. So don't invoke it. This, and he saved Enram. This. Anyhow, this is KM Joseph case. Right.
इसका मतलब सुप्रीम कोर्ट गवर्नमेंट को दबा नहीं सकती। सुप्रीम कोर्ट गवर्नमेंट को दबा नहीं सकती।
बात दबाने का नहीं है, देखो बात है कॉम्पिटेंस और मेरिट का। उनका कोई काम नहीं है कि हमें गवर्नमेंट को दबाना है। भले गवर्नमेंट चाहती है ऐसा करना, उनका कोई ऐसा रोल नहीं। वो जब जो केस होगा, जो मेरिट होगा, उस पर जजमेंट देंगे। अब ये मीडिया का काम है कि ये दिखाए कि ये किसके फेवर में है। राइट, मीडिया का ये काम है। हम लोगों ने ऐसा डिस्कोर्स जनरेट किया है, जुडिशरी ने ऐसा नहीं किया है। जुडिशरी को तो मेरिट पे जजमेंट देना है। अब वो भी ह्यूमन है, मेरिट पे जजमेंट देते हैं तो कभी वो भी एरर कर सकते हैं। दे आर नॉट एब्सोल्युटली फाइन लाइक, बट हम लोगों ने ये डिस्कोर्स जनरेट किया है कि ये जजमेंट किसके फेवर में है। मीडिया तो बैठी हुई है इसी के लिए, उसको तो ट्रिगर चाहिए दिस, बट इट्स नॉट इन दैट वे। दे हैव टू गिव जजमेंट ऑन द बेसिस ऑफ व्हाट द लॉ सेज, because next time they have to again justify their judgment. It is quite open for criticism. It is quite open for public wisdom. Thus, they have to maintain their consistency, otherwise people will not respect judiciary. It's not about कि कौन किसको दबा रहा है. Rather, let's take in a descriptive way कि what is happening basically. This is KM Joseph. Let's take Akil Qureshi case. So Akil Qureshi was senior most judge in High Court, not 34th position. He was senior most judge in High Court, among High Courts, and he was a Chief Justice of, I guess, no, he was senior most. He was Chief Justice. He was senior most judge and Chief Justice of Madras. No, ये मध्य प्रदेश होगा। Tripura High Court he was appointed. Right. This basically there are round tripping about him, so difficult to remember. Right. So basically, let's say Akil Qureshi was senior most judge in High Court. Right. He was elevated to Supreme Court. Right. He was elevated to Supreme Court by collegium. Government junked. Then Rohinton missed, क्या नाम था? Rohinton. One judge name was like this. He was in part of, let's say, a judge in the collegium. He told that unless Akil Qureshi name is forwarded, he would not give any approval to any new name. Collegium waited for his retirement. Right. Rohinton Mistry ऐसा ही कोई नाम है, नाम I forget. The chief, judge of Supreme Court. Nariman. Yes, Nariman, let's say that. The Nariman, let's say, he also belonged to his, let's say, good family. His father was also, let's say that, judge. So he did not forward any name. Collegium, if there is lack of consensus, they cannot forward any name. The collegium waited for his retirement. Once he retired, then Akil Qureshi name was, let's say that ki, forwarded not for Chief Justice, not for Judge of Supreme Court, rather Chief Justice of Tripura High Court. He was not appointed judge in Supreme Court. Now, why he is not appointed judge in Supreme Court? क्या problem है? So, he was the judge in Gujarat High Court, who gave order for arrest of Kautilya. This, and that's why he was not elevated. This. So, will you give judgments on the basis of futures? What in future going to happen?
Sir, it has become a recently, sir, 2 months before that was published in Law of Law also, law magazine, that giving the chief justices, making them like in one of the judge in that Ram Janmabhoomi case, I guess he was from Muslim community. He was recently made the governor of some of the state.
Yes,
So
yes,
that
yes.
question came that if
Justice, right? Nazir, something Nazir.
Justice Nazir, he was made governor. So there was the question that even before that, Gogoi was appointed in Rajya Sabha.
Yes.
So the question came that the judge will, if he is going for retirement and he gets this type of opportunity, so he will go for the case rather than taking because even if before that it was told that the person who acquitted Amit Shah and Modi in SIT 2013,
Sadashivam,
he was made the governor of
Kerala.
After that, Ali Mohammed.
Yes.
For 5 years he was governor. So that will like.
That is how, let's say that. So everything cannot be a coincident. This you can say that. Some can be coincident. We can say yes, it was just a coincidence. But everything cannot be a coincidence. Let's say that. Even if collegium is there, but executive tries its best, right? Still to whether to appoint, elevate, not to elevate, and to ensure that that judge does not reach to the chief justice level. This and they do this. That results into delay. This tussle result into delay in appointment. This you should know. The consequence is it results into delay in appointment. और अभी भी एक दो न्यूज आया होगा आपको, 2 जज के ऊपर चल रहा है. कॉलेजियम ने किसी नाम को सजेस्ट किया है, सेम केम जोसेफ टाइप, राइट. देयर आर 2 names. So collegium has suggested 2 names. एक name, one name they have, let's say that ki forwarded, and another name they have junked. This. So it results into delay. And delay इतना होता है कि लास्ट 6-7 months से एक रिपोर्ट के हिसाब से they have not appointed judges. This delay इतना होता है कि मद्रास once high court vacancy reached to 40%. Right. When there was chief justice, क्या नाम था? दीपक ठाकुर. दीपक ठाकुर. Right. Not Deepak Thakur. There one chief justice. Deepak Thakur से पहले जो chief justice थे. No, Deepak Mishra. Deepak Mishra. Before Deepak Mishra, there was another chief justice. Right. Yes. नहीं उसके बाद. केयर के बाद. Right. So vacancies in High Court reaches to 40%. And you know Chief Justice, what is Chief Justice of India while addressing media? While addressing media, Chief Justice, right, comes in tears. This is how it happens. And he requests to the government, please appoint judges. This. An honest person can do only that. He can be in tears. Nothing else. Right. Still it does not matter. This. So vacancies when reached to 40%, it's huge. how the high courts will function. Then battle went in open. Kiran Rijiju and Chief Justice often. Right. So it is All India Judges Conference. पहले लॉ मिनिस्टर का बारी आता है वो बोलते हैं and he criticized collegium. Right. Collegium this blah blah things. Right. उसके बाद आते हैं Chief Justice. He defends collegium. Right. Collegium is a thoroughly good system. This last moment पे जब फाइट थोड़ा लगा कि फिजिकल हो जाएगा, द लास्ट, तो चीफ जस्टिस ने बोला आई डोंट वांट टू टेक ए फाइट विथ ऑनरेबल लॉ मिनिस्टर. दिस इज व्हाट ही सेज. Then our vice president, right, he criticized judiciary for striking National Judicial Appointment Commission. तो फाइट वहां तक जा चुका है, मतलब ग्राउंड में, दिस यू कैन से दिस बिटवीन जुडिशरी एंड एग्जीक्यूटिव. बट दिस इज द परसिव्ड थ्रेट. परसिव्ड थ्रेट क्या है? लेट्स कम लाइक दिस. So if you read how judges at appointment level, even if there is collegium, but the relationship between executive and judiciary turn out to be so bad, so worse, then you will realize. And past, let's say Justice खन्ना का तो split judgment था ADM जबलपुर में, उससे कोई मतलब नहीं है. गवर्नमेंट को तो जो करना था वो जुडिशरी ने बोल दिया कि लिबर्टी कैन बी टेकन आउट, एंड ही वाज जस्ट ए माइनॉरिटी जज. तो उससे क्या, उसको पनिश करने की क्या जरूरत है? ऐसा होता है कि चलो ही इज ए पार्ट ऑफ मेजॉरिटी जजमेंट, केशवानंद भारती, राइट, बट ही गेव ए माइनॉरिटी व्यू. माइनॉरिटी व्यू इज दैट कि आर्टिकल 21 कैन नॉट बी टेकन अवे एंड यू डू नॉट मेक हिम चीफ जस्टिस. वैसे भी चीफ जस्टिस बन के क्या कर लेगा? ऐसा थोड़ा है कि चीफ जस्टिस के पास बहुत सारा पावर है. चीफ जस्टिस इज अनदर जज ऑफ सुप्रीम कोर्ट. The only thing is he is a chief justice. Right. ऐसा कुछ पावर तो है नहीं उनके पास. Anyhow, but you just want to give a message. You could have given a healthy message also. Right. So executive, let's say that not today. In the past history, if you see, this is how they have done. This is the perceived threat. Right. Perceived threat one. Then let's take the next. Law minister, why they are objecting presence of law minister? So before we go to this, let's go in past history a bit more. So when Markandeya Kadju, you may be knowing about Markandeya Kadju, right? वैसे ही पंडित जी लोग बहुत इंटेलिजेंट होते हैं. So right, Markandeya Kadju, let's say that, बहुत ही इंटेलिजेंट पर्सन है, राइट. उनको जितना लॉ आता है, उतना हिस्ट्री आता है, कल्चर आता है, उर्दू, अरबिक, सब कुछ आता है, राइट. दिस सो Markandeya Kadju, right, became press council of chairperson of press council of India after retiring as judge of Supreme Court. This that is how we'll find this. Then he wrote an article, Perfume from Arabia. राइट. मतलब टाइटल से आपको घबराना नहीं है, उसमें कुछ ऐसा परफ्यूम है नहीं. दैट इज हाउ आई टोल्ड दैट कि ए लॉ पर्सन हैविंग ए लॉ बैकग्राउंड राइट्स एन आर्टिकल परफ्यूम फ्रॉम अरेबिया, राइट. तो थोड़ा सा फिलोसफिकल कल्चरल टाइप का आर्टिकल था वो, बेसिकली इन द आफ्टर मैथ ऑफ गुजरात राइट, एंड ही क्रिटिसाइज. तो टाइटल कुछ और था, कंटेंट कुछ और था. Right. So that time, let's say that ki Arun Jaitley, let's say that, was in opposition. Right. Means BJP was in opposition, let's say. Because he wrote article after riot, means 2-3 years later, when UPA came to power. So Arun Jaitley was law minister. Sorry, no, he was in opposition. He told that there are two types of judges. one who knows law and another who knows law minister. So basically it was attack on Markandeya Kadjo. Once he wrote the article, Perfume from Arabia, and he was head of Press Council of India. Basically he was trying to say indirectly, that you are Press Council of India chairperson because you know law minister. You do not know law. Right. Now the same government, same party is in power and law minister is there. Right. So you can bring interpretation of this. Right. So if you know law minister better, you have place in judiciary. This, that you can say that. This is a perceived threat. Another perceived threat is this. The 3% and post-retirement benefits. Right? Post-retirement. For the sake of post-retirement benefits, Chief Justice may not go against law minister. You know Ranjan ka koi story? Right. Ashada Shivam, you know this? He was appointed governor. This is how the example. Right, because in Justice Loya case, he acquitted our Kautilya. This. Two judges, let's say that, they want to retire. मतलब suppose वो Chief Justice नहीं बन रहे हैं, retire पहले ही हो रहे हैं, तो उनको भी चाहिए post retirement benefit. NHRC chairperson, tribunals member. This you should know that. Already they have created many quasi-judicial bodies in which they are appointed. Right. If you want a post, you will not go against law minister. Or someone is supposed to become Chief Justice, so you cannot go against law minister. Once the 3 members starts favoring law minister, so you know what will happen. Right. So who would be appointed judges? Right. तो आजकल हमारे ऐसे ऐसे एडवोकेट्स हैं जो मनुस्मृति भी कोट करने लगे हैं कॉन्स्टिट्यूशन की जगह. Right. This you should know that. And they have their own movement nowadays. They have their own associations. And they have been somehow spreading it like something. Right. This. They are very vocal about that. So, the question even 1 to High Court judges have also quoted this. So, basically, this is how you will find out that law, constitution will be replaced by anyhow. अभी उतना दूर नहीं जाना है. This. इसका consequence क्या होगा? You should know that when all else fail, judiciary is the last hope. Still, people in our country have faith in judiciary. This. They don't have faith in first 2 organs. Right. This is how they try to go to judiciary. Even if let's say they may not get in favor, still they will say कि ठीक है, Supreme Court ने बोला है तो ठीक ही होगा. This. अगर उनके फेवर में भी नहीं होता है तो वो एक्सेप्ट कर लेते हैं. This. When this last hope is dismantled, what will happen? People will take law onto their hands. जिसको बोला जाता है civil war, chaos. This is how democracy. So democracy's survival depends certainly on first 2 organs. And if they are not working, so last hope is pinned at judiciary. And if judiciary is not impartial and independent, then you cannot save democracy. This. Because then people will not go to judiciary to take justice. What is happening in the extremist and affected areas? Naxalite infested areas, Gnosis insurgency areas, where people go for justice. People don't go for justice to administration. People go for justice to those groups. That's why those groups have their influence. Because they know that justice they will not get from administration. That's why there is a parallel government. You have Sarkar Raj type of system that it was once. Why it is? Why people do not go to the administration? So in that case, let's say that there can be, you remember so many cases, be it related to even government, be it related to even Maharashtra, be it related to president's rule, be it related to defection, be it related to Bhima Koregaon case, be it related to any riot case, be it related to Manipur case. आप कोई भी ऐसा केस ले लो, you will not find that कि executive is very, let's say, threadbare clear, right? That it is very, let's say, that clear that this should be the justice, right? And it is not fair enough. It is biased. And in that situation, if you do not have judiciary, so this is what you know what can happen, right? That is their perceived threat. When they say perceived threat. And judges do not have, always remember, judges do not have ulterior motive. उनका कोई एजेंडा नहीं है कि वो रन कर रहे हैं, right? आप औरों के बारे में बोल सकते हैं कि उनका कोई एजेंडा हो सकता है, बट जजेस का कोई एजेंडा नहीं है. अगर होता है तो अभी तक वो क्लियर होता, right? They are just playing their role in the judicial system. If you blame, आजकल तो यहां तक जा चुका है कि जजेज आर वो गैंग्स, लेट्स से दे आर बिहेविंग लाइक गैंग्स. कोई बोलता है वो उधर राइट आरएसएस का वो जो निकलता है, क्या निकलता है, न्यूज आर्टिकल कोई पब्लिश करते हैं, उसमें उन्होंने आर्टिकल लिखे, राइट, कि दे आर बिहेविंग लाइक गैंग्स. और रिटायर्ड जज के बारे में बोला उन्होंने. एंड दे टोल्ड दैट कि दीज लिबरल्स they are influenced by liberals, right? मतलब judiciary as an institution को they have questioned. Can we say like that organization is, let's say, what that organization is? Who has given this license to speak in that way? Are you representative of people? Are you having license of Indian culture? How you speak in that way? You as if you own Indian culture. Other people are just your followers. This level of legitimization has been done that they decide that what is Indian culture, and you have no any representation in the society. And they are making judicial system, let's say that disaffection. They are creating a disaffection of people towards judiciary. This is the threat. And already there are people who have started supporting. They think ये सही है. In the name of Indianization, right? तो ठीक है, जैसा लोग डिसाइड करेंगे वैसा कंट्री होगा, right? If people decides कि we should be governed by मनुस्मृति, तो इसमें बुरा क्या है, right? Isn't it?
मीडिया में दिखते हैं,
right? उसके बाद अभी सुप्रीम कोर्ट के चीफ जस्टिस ने एक लेक्चर में एक आर्टिकल आया था अभी, डिसइंफॉर्मेशन, राइट? डिसइंफॉर्मेशन कैन क्रिपल डेमोक्रेसी, ऐसा ही कुछ टाइटल था, राइट? द डिसइंफॉर्मेशन, राइट? देयर इज अ डिसइंफॉर्मेशन, लेट्स से दैट, बीइंग स्प्रेड इन द सोसाइटी. पीपल आर बीइंग बार्ड फ्रॉम राइट इंफॉर्मेशन. Yes, but that's not the point. This is how, let's say, basically their fear. Fear is that कि judiciary may lack independence. That's why they do not want to, right, negotiate or compromise our independence. They are trying to protect as long as they can. Although they are open for any other system of appointment which is better than NJSC. So time to time you see that lots of articles have been written. There have been developments after, let's say, that striking of NJSC 2015 and 16. So they were also open that we can bring change in the collegium system. Therefore, government came up with a memorandum of procedure. a new memorandum of procedure, or let's say that it came up with let's say a set of suggestions related to how, let's say that we can bring changes in appointment of judges. Therefore, the idea has been floated like this: collegium plus MOP, NJSC plus MOP, collegium plus NJSC plus MOP. इस तरह से permutation combinations have been suggested. What is that MOP? The MOP says that memorandum of procedure says that we should try to take into consideration the judges last 5 years judgment, so that we can introduce also performance criteria. Niti Aayog has also recommended that we should take also performance criteria while appointing and elevating judges. This is one criteria they have brought. Second criteria they have brought is that the judges should be, names should also be suggested by Advocate General, Attorney General. Means names should not only come through collegium, let's say that proposals can also come through, Attorney General also can propose, Advocate General can also propose the names for appointment of judges. Then it has been told that we should take also, let's see, names from Bar Council of India. The Bar Council of India should also propose some names for appointments. Basically, they want to widen the pool of, let's say that, candidates for appointment. That suggestion has been made. Then another suggestion has been made, there should be a secretariat so that it can scrutinize all these names, and that, let's say that in that way, when it will be, there will be a secretariat scrutinizing all the names. So it will bring, let's say that, greater consistency and objectivity in appointment process. And secretariat will also promote transparency, because it will publish the names which were considered applied, the names which were rejected, and the criteria for appointment. And then let's say one more criteria was added in MOP. Right, mother of all criteria. This national security clause. Right. National security clause, that the government can veto any name on the ground of national security. Yes. And the MOP was sent to judiciary. लीजिए आपको जो करना है कीजिए. फिर जुडिशरी ने थोड़ा हिम्मत दिखाया और बोला कि all points we agree, we don't agree on national security clause. It should be dropped. This government again sent with national security. Again they told that कि no, national security clause should be dropped. Thereafter government did not send. Right. Hence collegium system continues. This. Now let's come to national security clause. कोई भी नाम किसी भी मान लो मैं नेशनल सिक्योरिटी के लिए थ्रेट हूं. सो मैं यहाँ पढ़ा थोड़े रहूंगा. मुझे अरेस्ट करके ले जाएगा. Isn't it? Right. कोई भी एडवोकेट है, right, जज है, if he is a national security threat, right, so can he remain advocate? Right. So we don't understand why there is a clause like say whether judges are threat for national security. Right. फिर बचा कौन? Right. This, and what is that national security? Right. वो क्या है national security? और आप, sorry to say that, right, अगर वो हॉब्स का लॉक वाला कंसेप्ट होगा यहाँ पर, तो वो क्वेश्चन कर देंगे कि who are you to decide national security? People will decide national security. Right. इसलिए वेस्टर्न कंट्रीज में वो ड्रामेटाइज नहीं कर सकते हैं. राइट, दिस इज डेमोक्रेसी. पीपल नो व्हाट इज. हम भी तो कंसर्न है नेशनल सिक्योरिटी के लिए, एक लॉयर भी तो कंसर्न है नेशनल सिक्योरिटी के लिए. गवर्नमेंट ही क्यों कंसर्न है नेशनल सिक्योरिटी के लिए? right? But you belittle people then कि you are concerned about national security and people are threat to national security, right? जबकि democracy is brought by people, right? Not by you, right? But this is how it happens in developing countries. We promote as if government is the savior and people are threat. This, anyhow, just I told something related to this idea. So this is what you know, that the tussle is going on still and no any solution.
सर सुप्रीम कोर्ट जो है गवर्नमेंट को डायरेक्ट नहीं कर सकता कि यही ऑर्डर रहेगा और विद इन टाइम लिमिट आपको ये पास करना है।
अब जैसे कि मुझे लगा कि यस ये भी आया है डिबेट में कि एक टाइम लिमिट होना चाहिए, बट वो टाइम लिमिट नहीं कर सकते हैं। मान लो उन्होंने 3 months का टाइम लिमिट दिया ना, तो गवर्नमेंट क्या करेगी ना कि पूरे 3 months का टाइम ले लेगी। प्रॉब्लम है उसका, राइट? मान लो आपने ए नेम दिया और 3 months का टाइम है, ये क्या करेंगे ना कि इसको जंग कर देंगे, राइट? इसलिए कि हमारे पास 3 महीने का टाइम है और बीच में उन्होंने बी को सेंड किया, सी को दिया, डी को, इसको अपॉइंट कर देंगे बस।
सर ये पावर्स गवर्नमेंट के पास नहीं होनी चाहिए, जो ऑर्डर है वही
नहीं इतना ज्यादा जुडिशरी इतना ज्यादा मतलब जा सकती है जब वो भी थ्रेशोल्ड आएगा, तब जब वो भी एक टाइम आएगा। देखो जुडिशरी को ये भी देखना होता है, यू नो दैट कि वी टोल्ड एक्सेप्टेंस ऑफ अथॉरिटी, किसी दिन गवर्नमेंट ने अगर रिजेक्ट कर दिया तो कॉन्स्टिट्यूशनल क्राइसिस, दिस यू शुड नो दैट इंडिया विल एंटर इन ए कॉन्स्टिट्यूशनल क्राइसिस। अभी एक रिस्पेक्ट है कहीं ना कहीं जिले से, एग्जीक्यूटिव भी इज ऑल्सो रिस्पेक्टेड, जुडिशरी ऑल्सो रिस्पेक्ट्स, तो दे नो दैट कि हमें कहां तक हमारा दायरा हो सकता है दिस। तो उस स्टेज पे हम ना जाए कि एग्जीक्यूटिव उसको रिजेक्ट कर दे। जब वो रिजेक्ट कर देगी तो कहीं ना कहीं से एक जुडिशरी का जो एक इमेज है, राइट, इट विल सफर।
सर जब ये रिजेक्ट करते हैं, किसी को सिलेक्ट नहीं करते हैं, तो गवर्नमेंट को रीजन देता है क्या?
राइट,
रिटर्न में
वो डिले कर दिया तो रीजन का उसका कोई देना नहीं है।
डिबंक कर देते हैं, रिजेक्ट कर देते हैं।
नहीं, रिजेक्ट नहीं किया ना उन्होंने, तो डिले कर दिया।
डिले के पीछे भी कोई रीजन देना चाहिए?
कुछ भी नहीं, वो देयर इज नो कम्युनिकेशन, देयर इज नो कम्युनिकेशन, राइट, कुछ ऐसा कम्युनिकेशन नहीं होता है। तो बहुत सारे नाम ऐसे पेंडिंग है गवर्नमेंट के पास, गवर्नमेंट डज नॉट स्पीक।
सुप्रीम कोर्ट कैन इंसिस्ट फॉर रीजन कि आपने जो ऑर्डर को फॉलो क्यों नहीं किया?
नहीं, वो नहीं करेंगे ऐसे, मतलब वो नहीं कर सकते हैं, उनका भी एक लिमिट है। अभी तो चीफ जस्टिस ने बोला है ना, वो क्या था वो केस, हाँ यस, अभी तो एक बेंच ने बोला है कि जो हमने नाम प्रपोज किया है उसके बारे में कुछ कीजिए।
उसमें था कि पिक एंड चूज नहीं कर सकते।
यस, अभी तो एक आया था, आर्टिकल भी आया था कि यू कैन नॉट पिक एंड चूज एंड यू डू समथिंग बिफोर वी डू समथिंग, ऐसा उसने थ्रेट किया। बेसिकली द बेंच टोल्ड टू द अटॉर्नी जनरल कि टेल टू योर गवर्नमेंट कि यू डू समथिंग बिफोर वी टेक सम हार्श स्टेप। अभी जस्ट लेट्स से 15-20 डेज का डेवलपमेंट है। तो one article was also, let's say, in Hindu related to this. You cannot pick and choose this.
After second judge's case, it was declared that the consultation means concurrence. So they have to abide by the collegium decision.
Yes, but then how long? Means वो time तो नहीं mention है ना।
So they will with respect to time.
Let's say कि second time when you let's say recommend name of a second time, the second time it is binding. Now when they should appoint? When they should appoint?
Appointment is at the executive.
Yes, they will delay appointment. Meanwhile they are appointing other names. इसलिए कि जुडिशरी भी नहीं चाहेगी कि अपॉइंटमेंट डिले हो। ठीक है, आप अपॉइंट करो, दे नो दैट इट इज बाइंडिंग, वो भी एक देखेंगे कि कब तक डिले करते हैं,
सर ये जो सारे सॉल्यूशन जो सरकार की तरफ से आए हैं ये जुडिशरी की तरफ से क्यों नहीं आए? जुडिशरी ने खुद डायरेक्ट क्यों नहीं किए? क्योंकि प्रॉब्लम है इसका ओपेकनेस की, डोमिनेंस की, opacity
देखो जुडिशरी के काम नहीं है ना, ऑलरेडी कमीशंस हैव रिकमेंडेड, आई विल शो यू दैट already there are recommendations by the commissions that what should be the composition of a selection committee, right? ARC second has also recommended a composition, so why we cannot take up from them the best composition?
सुप्रीम कोर्ट जजेस के इसकी थ्रू भी तो ला सकता है।
नहीं देखो सुप्रीम कोर्ट देखो no सुप्रीम कोर्ट cannot make a law, try to understand, they cannot tell, they can leave it to executive that because the day they tell something na then the room is not left for further improvement. अगर उसमें कोई फ्लॉ होगा तो then what गवर्नमेंट विल डू? जैसे मान लो उन्होंने सिलेक्शन कमेटी बनाया इलेक्शन कमीशन के लिए और उसमें उन्होंने चीफ जस्टिस का नाम इंक्लूड कर दिया, अब गवर्नमेंट को एक एक्सक्यूज मिल गया, राइट, कि सेपरेशन ऑफ पावर है, सिंस देयर इज सेपरेशन ऑफ पावर द चीफ जस्टिस शुड नॉट बी पार्ट ऑफ दिस, और उसको हटा करके उन्होंने कंपोजिशन चेंज कर दिया। अब जुडिशरी कुछ बोल नहीं सकती है, देन दे हैव टू फर्दर डेवलप ए करेज, लेट्स से दैट दे शुड हैव अनदर करेज टू स्ट्राइक इट। तो अल्टीमेटली होगा क्या, गवर्नमेंट ने जानबूझ के किया है, राइट, इसलिए कि जुडिशरी को लेट्स जुडिशरी रिव्यू इट एंड बाय 2024 वी विल नॉट अपॉइंट सिलेक्शन कमिटी, राइट। 24 का ही इलेक्शन के बाद है, उसके बाद तो 5 साल कौन देखा है, राइट। तो अगर जैसे ही जो सुप्रीम कोर्ट में ये लॉ चैलेंज हो जाएगा तो सिलेक्शन कमेटी तो बनेगा नहीं, और तब तक 2024 का इलेक्शन हो जाएगा, राइट। तो ये सब ट्रैप है बेसिकली। द जुडिशरी इज कॉशियस, हर एक मूव लेट से उसका हर एक डिसीजन में वो अपने ही ट्रैप में फंस सकते हैं।
चेक्स एंड बैलेंस की बात करें तो जुडिशरी में भी चेक्स एंड बैलेंस की जरूरत है ना सर?
That is a separate question. We have told accountability and independence debate, there we'll talk it. Yes, their house should also be in audit. Yes, but let's say that it's about independence. This is how all these debates, let's say.
सर आपने वो भी कहा ना कि हार्श एक्शन लेगा अगर यूपीएससी बोलता है, सर हार्श एक्शन मतलब
देखो वो लेंगे नहीं, वो तो थ्रेट कर रहे हैं ताकि एग्जीक्यूटिव बेसिकली वो नज कर रहे हैं जुडिशरी को, थोड़ा और आप आगे बढ़ो, थोड़ा और आगे बढ़ो।
गवर्नमेंट डरता है सर,
राइट, गवर्नमेंट तो देखिए गवर्नमेंट चाहती है कि उसके फेवरेबल इंस्टीट्यूशंस हो, इसलिए कि गवर्नमेंट को एम्बैरेसमेंट होता है, राइट, एम्बैरस, इट फील्स एम्बैरस्ड, लेट्स से इफ एनीथिंग गोज अगेंस्ट द गवर्नमेंट इट गेट्स एम्बैरस्ड, राइट। होता है, पब्लिक मोरालिटी होता है, चेक्स होता है, क्रिटिसिजम्स होता है, गवर्नमेंट के अगेंस्ट बहुत सारा नेगेटिव है, बहुत सारे नेगेटिव्स लिखे जाते हैं, क्यों लिखे जाते हैं, और उसके कहीं ना कहीं उसका लीगल बेसिस भी है, जो क्रिटिक्स है उनके पास लीगल बेसिस है ना, आप उनसे आर्गू नहीं कर सकते हैं, इसलिए कि बहुत सारे उनके पास लीगल बेसिस है कि गवर्नमेंट ने ये सारा गलत किया है, राइट। अगर जुडिशरी ने किसी गवर्नमेंट के डिसीजन को गलत बोल दिया है तो वो गलत है, अब उसको आप सही बोल नहीं सकते हैं, it is legal basis. The critics can argue and this is how they can create an opinion against the government.
अगर सुप्रीम कोर्ट कोई बोल देता तो फैक्ट हो जाता है।
Yes, you can take it like say कि उत्तराखंड प्रेसिडेंट रूल इज डिक्लेयर्ड अनकॉन्स्टिट्यूशनल, तो हमारा डिबेट तो नहीं है ना कि वो अनकॉन्स्टिट्यूशनल है कि नहीं, वी हैव प्रिज्यूम कि इट इज अनकॉन्स्टिट्यूशनल, दिस, so that becomes a negative aspect of the government, this. So it creates another public opinion. That public opinion will be, let's say, it is not कि one article, it builds a public opinion. और आज के डेट में गवर्नमेंट का जो 2019 में let's say पब्लिक ओपिनियन था और जो 2024 में पब्लिक ओपिनियन होगा उसमें बहुत फर्क है, राइट। गवर्नमेंट टू विन इलेक्शन इन 2024 it will have to fight against that public opinion, this. Because public opinion, let's say, people also know some of the negatives. The negative opinion has also been created now in public. So it's both way, let's say. This is how government faces in long run, if not in short run. This we can say that. Anyhow, let's finish all these things. Bye. So, right, we cannot recommend one name at time, otherwise it will take lots of time. Someone is writing one name at time. Right. Yes, Justice Sanjay Kishan Kaul. This is how. This remark was given by कि government cannot pick and choose. It is Justice Sanjay Kishan Kaul. He, let's say, this is. Yes, Justice Narula, they say. Another information is shared. Another bench, let's say, ordered, Justice Narula gave deadline to appoint judges as recommended by collegium. I think they have given 3 months or something time. किसी एक पर्टिकुलर केस में उन्होंने डेडलाइन भी रेफर किया है कि विद इन दैट डेडलाइन यू अपॉइंट जजेस दिस बट लेट्स से दैट कि द क्वेश्चन अगेन कम्स दैट कि व्हाई government should have a say in appointment, but government should not have, let's say that, so much say in that. Government should also be concerned about protecting the independence of judiciary. We reduce our debate in our society to a level that people start thinking human rights should be protected by Human Rights Commission. Judicial independence should be protected by judiciary. Audit should be protected by CAG. अरे तो गवर्नमेंट क्या करेगी फिर? Why government has been elected? All the roles of the government you have shifted to institutions. So for what you are? This. So you don't create this kind of opinion. Human rights cannot be protected by NHRC. Human rights should be at first place protected by government. If government does not protect human rights, NHRC cannot do that anything. Right? Because it is beyond its capacity. And if government does not want to protect independence of judiciary, judiciary cannot protect it. And same thing, media. If government cannot protect independence of media, media itself cannot protect its independence. This you have to understand. So, governments have gradually created a mahal. Right. A sort of that people have started thinking कि human right protection कौन करेगा? NHRC. NHRC is not able to protect human right. Way forward. Right. और लिखेंगे blah blah thing. इसको ये कर दो, वो कर दो, ये बना दो. अरे what the hell you are writing? Sorry to say that. Right. Ultimately बनाएगा कौन? No. So many times I find this UPSC examination all such mechanical. Right. You are writing ये कर रहा है, who is going to do that? Government. तो जब गवर्नमेंट को ये सारा करना है, राइट, तो रिफॉर्म्स तो की जरूरत ही नहीं है फिर. Don't you think? When government has to do this, government has to protect independence of judiciary. So why you need selection committee? You ensure appoint competent people. That's all. Matter is ending. Right. But since you are not doing it, so you create so many n number of things like unnecessary. इसीलिए डेवलपिंग कंट्रीज में इंस्टीट्यूशन ज्यादा है, गवर्नेंस कम है. डेवलप कंट्रीज में इंस्टीट्यूशंस कम है, गवर्नेंस ज्यादा है. It is a PRS article, you can read yourself. Title is this. Right. Rethinking Judicial Appointments, Collegium versus Commission. It is a good article. You can complete, have copy paste. This. So basically you will find that KRC second has recommended. If you see RC second, you can see a judicial side. Right. Chief Justice of India. In case of High Court, Chief Justice of High Court. Then it brings Vice President. Vice President as chairperson. Prime Minister, Law Minister. This. Then legislature has Speaker, Leader of Opposition. This. Basically, its representation is considered a balanced one. National Advisory Council has, let's say, more or less same. This will find. Then law, let's say National Commission, basically it has a narrow, let's say that representation. Chief Justice, two senior most judge, Union Law Minister. one eminent person. Perhaps government has gone by national commission this to review this working of constitution on this basis. राइट, भीमा कोरेगांव पता ही है आपको क्या चल रहा है? कुछ नहीं हुआ था, उन्होंने सेलिब्रेट किया था थोड़ा बहुत कुछ, राइट। और इतने साल हो गए ना, तो चार्जशीट फाइल हो रहा है, दिस विल फाइंड दिस एंड यू नो दैट कि दे आर इन जेल, दे आर इनकार्सरेटिंग। इट डज नॉट मैटर, लोगों को भी ये नहीं मैटर करता है। दिस सो दिस वे वी कैन से, if you work for the tribal people, you are helping tribal people, right? आपका आइडियोलॉजी कुछ भी हो सकता है, क्या आइडियोलॉजी का होना बुरा है? कैन यू कंट्रोल आइडियोलॉजी? नो, नो सोसाइटी कैन कंट्रोल आइडियोलॉजी। यस, बट आइडियोलॉजी डज नॉट मीन कि यू आर पार्ट ऑफ कंस्पिरेसी। दिस once one BSF officer told कि people from Bihar should not be recruited in paramilitary forces। अजीब बात है, right? How can judiciary be responsible for backlog cases? लॉ आप बनाते हो, जजेस को आप अपॉइंट करते हो। राइट, ऐसा होता तो इतने सारे जजेस क्यों ट्रांसफर होते हैं हाई कोर्ट्स के? देखो, कहीं ना कहीं जजेस का भी तो लिमिटेशंस है ना। आप जानते ही हो इनसाइड इंडियन मूवी में इनसाइड क्या होता है, राइट? जजेस का भी लिमिटेशन है। अभी इधर तो आया था, गवर्नमेंट एक ऐसा प्रपोजल लाया है जो ऑलमोस्ट अप्रूव हो गया है, राइट, कि उसमें ये होगा कि जजेस के घर पे भी रेड पड़ सकता है, राइट। दिस न्यूज आई एम फ्रेंटली रिमेम्बरिंग, उसमें यह है कि जजेस, देयर कैन बी रेड्स आल्सो ऑन द हाउस ऑफ जजेस, राइट। सो दे हैव आल्सो देयर लिमिटेशंस। दिस, वो आप क्या समझते हैं कि वो बहुत ही करेजियस है वो, राइट? दिस खासकर हाई कोर्ट जज, देखो सुप्रीम कोर्ट तो दिल्ली में है, तो आप चाह के भी कुछ नहीं कर सकते। बाकी जो हाई कोर्ट्स कहाँ है पता ही है। अब प्रयागराज में कौन सा सिक्योरिटी है, राइट? हाई कोर्ट्स का जो होता है, उनके जो हाउसेस होते हैं, राइट, देयर इज नो हाई सिक्योरिटी जोन। दिल्ली तो हाई सिक्योरिटी जोन में आता है ना, राइट? दिस, तो क्वेश्चन ये होता है ना कि चैलेंज इज दैट UPSC is independent but state public service commission is not. Why? You have to understand the ecology. This, ये सारी जिम्मेदारी तो गवर्नमेंट का है, राइट? सिस्टम बनाना गवर्नमेंट का काम होता है, जुडिशरी का नहीं। उनका काम है जजमेंट देना। प्लेयर्स का काम ये नहीं है कि स्टेडियम बनवाना है। तो वो खेलेगा क्या? राइट, बट यू थिंक दैट कि नो, इफ जुडिशरी हैज प्रॉब्लम्स तो रहते कि स्टेडियम में कोई प्रॉब्लम है तो प्लेयर्स आर रिस्पॉन्सिबल। क्या माहौल क्रिएट किया है, राइट? जो डेमोक्रेटिक डिस्कोर्स है, राइट, ऐसे नहीं होना चाहिए। दिस इज हाउ द रोल ऑफ मीडिया, दिस इज हाउ डिसइंफॉर्मेशन। तो गलत डिस्कोर्स क्रिएट करते हो आप सोसाइटी में, तो लोग भी ऐसे ही सोचना शुरू करते हैं। लोगों को क्या है, बच्चे को क्या पता है? वो तो जैसा इन्फॉर्मेशन मिलेगा वैसा उसको डिस्कोर्स होगा, राइट? सही तो वो जब UPSC का पढ़ेगा तब पता चलेगा, राइट? वो भी बहुत ही मुश्किल से, नहीं तो वो भी नहीं पता चलेगा, राइट? तो मोस्ट ऑफ द पीपल दे मे नॉट हैव right understanding. This is a challenge, and you should know that कि NDA गवर्नमेंट वाजपेयी के टाइम में एक कॉन्स्टिट्यूशनल अमेंडमेंट बिल पास किया गया था, राइट? दैट वाज रिलेटेड टू अपॉइंटमेंट, सिलेक्शन कमीशन। इसका नाम था नेशनल जुडिशियल काउंसिल। यस, राइट, नेशनल जुडिशियल काउंसिल। वो मैं बिल का नंबर भूल गया हूं कि उसका नंबर क्या था। राइट, इट इज ए लेस नोन फैक्ट। तो वन, जैसे कॉन्स्टिट्यूशनल अमेंडमेंट बिल वाज इंट्रोड्यूस्ड ड्यूरिंग एनडीए गवर्नमेंट, वाजपेयी गवर्नमेंट टाइम, right, known as National Judicial Council. It was supposed to create National Judicial Council. This National Judicial Council was headed by Vice President. Right. It was headed by Vice President, and that time there was no controversy. I don't know why government did not enacted it. So Vice President, it will have Chief Justice, Judge, Leader of Opposition, Speaker, this. So already we have made this attempt. This you can say.
मुझे ये चीज़ समझ नहीं आ रही कि क्या कॉलेजियम प्रैक्टिस सही है या फिर पार्लियामेंट में बताया?
No, collegium practice सही नहीं है. They are also saying that we should go ahead. Means we should let's say that go for collegium plus. Supreme Court is also saying collegium plus. Either you replace collegium or collegium plus can be MOP. Right, without national security clause. But government is not, it does not want to compromise. गवर्नमेंट का अपना एक व्यू है कि अगर हमने ये प्रपोजल दिया है तो यही होगा, तो दे डोंट वांट टू कंप्रोमाइज, कंसीड. जुडिशरी डज नॉट वांट टू कंसीड. राइट, फाइट तो ओपन हो चुका है. दिस इज व्हाट आई टोल्ड. लेट्स सी कि सुप्रीम कोर्ट ने बोला जो ट्रिब्यूनल्स वाले केस में, राइट, सो सुप्रीम कोर्ट सेज दैट कि दिस 4 years, let's say, yes, tenure should be 4 years or 5 years. Yes, Supreme Court is saying कि tenure should be 5 years. गवर्नमेंट कह रही कि नहीं 4 साल होगा. और इसी पे उन्होंने 2 बार जो है लॉ को स्ट्राइक कर दिया है. राइट, 2 बार लॉ को स्ट्राइक कर दिया. अब गवर्नमेंट विल नॉट ब्रिंग इट अगेन. इसका कॉन्सिक्वेंस क्या है कि ट्रिब्यूनल्स रिफॉर्म होगा नहीं. यस, जो मनी बिल वाला इशू हम लोगों ने बोला था वो यही इशू है. राइट, तो कॉन्सिक्वेंस इज दैट कि यू विल नॉट रिफॉर्म ट्रिब्यूनल्स. यस, सो दिस इज व्हाट लेट्स से दैट इट इज हैपनिंग. 4 years 5 years जो भी है, लाइक, तो आइदर यू गो फॉर दिस. राइट, उसमें एक दूसरा टसल ये है कि सेक्रेटेरिएट कहाँ होगा. तो सुप्रीम कोर्ट ने बोला है कि सेक्रेटेरिएट शुड बी लोकेटेड इन सुप्रीम कोर्ट. दिस, तो ये सारी जो बच्चों वाली खेल है, राइट, सॉरी टू से दैट, यू हैव टू हैव सम स्टैंडर्ड. इफ यू हैव सम स्टैंडर्ड तो क्या है, आप सेक्रेटेरिएट कहीं भी होना चाहिए, इंडिपेंडेंट होना चाहिए. दिस, दैट इज हाउ द चैलेंज. लेट्स, सबका अपना अपना केस है. और ये सारे केसेस हैं जो नोन है अभी. तो आओ, बहुत सारे केसेस हैं जहाँ पे देयर कंडक्ट्स हैव बीन क्वेश्चन्ड. दिस, सो V. Ramaswamy was found guilty. Haryana and Punjab High Court. He was found guilty of charges, but he was not removed. Generally happens that they resign. Yes. So resignation is not a solution. Resignation is not upholding accountability. This. Next, Justice Soumitra Sen, West Bengal High Court. Another, let's say, that case of misappropriation. Basically, let's say कि judicial fees, in one such case, judicial fees, instead of depositing in government account, it was deposited in his own account. That was allegation, few lakhs, let's say, something like. So that way allegation, let's say that. So he became a judge who was half impeached. This we can say that. In history, only judge who has been half impeached. What is half impeached? Yes. So one house passed it. He defended in that house. By the time the resolution goes in second house, he resigned. When he resigned, we are very kind-hearted people. जाने दो यार, छोड़ो. Isn't it? But Parliament should have not left. It should have passed the resolution, even if he resigns. If you want to show, right, accountability, let's say that. S.G. Modgal resigned, but that time Parliament did not accept resignation. He was member of Parliament. S.G. Modgal resigned on the charges of corruption. Parliament expelled him. That was Nehru era. This. And the only time when Parliament expelled. Anyhow, thereafter also carries this. Let's take P.D. Dinakaran. Very, तो मूवी बन सकता है. Right. P.D. Dinakaran was Chief Justice of Madras High Court at Karnataka. Right. I guess Karnataka High Court, yes. He was not Madras. He was Chief Justice of Karnataka High Court. He was elevated to Judge of Supreme Court. K.G. Balakrishnan was Chief Justice that time. And meanwhile, when process of consultation going on, somehow we don't know how it was found. He had land misappropriation. Land misappropriation means he illegally had grabbed land. Right. This. And therefore the government asked for his name reconsideration. Even second time also collegium persisted. But then meanwhile they realized that his credentials were doubtful. Generally first, there is in-house mechanism that will also tell. Since 1997, there is an in-house system, informal mechanism. That first, if there is any misconduct related to judges, the first informal inquiry is conducted by judiciary, which are kept, let's say, confidential. So, informal inquiry is conducted, and if they find that the said judge has a problem, if not serious, so then the judiciary will recommend to the government for transfer. And if the said judge has serious, they will ask that you resign. Basically, judiciary will ask by informal mechanism to that judge to resign. This, and if that resignation does not work, then judiciary recommends to the government for the removal of the judge. This is how the process. Now, in that case, K.G. Balakrishnan, let's say that, asked P.D. Dinakaran to resign. Hence, he was invited in Delhi for it. Let's say that, let's have a tea. Right, in, let's say, Lodi Garden. So, this is how VIP log jate hain wahan pe. So, this is how it is. And then let's say K.G. Balakrishnan asked him to resign. He refused to resign. और जाते जाते बोल के गया, जो करना है कर लो. I would not resign. Do whatever you want to do. Headlines in Times of India. Then he plays caste role. कि since he belongs to Dalit, that's why सारे हमारे पीछे पड़े हुए हैं. Meanwhile, let's say this is the flaw in removal process. Meanwhile, आप करोगे क्या? सैलरी तो पे कर रहे हो, मिसकंडक्ट है, इंक्वायरी हो रहा है, नहीं हो रहा है, right? And he is judge or chief justice. This is a flaw in our removal process. That you cannot withdraw work, you cannot withhold salary, you cannot suspend. All these provisions are not there. This. And removal process is so difficult. First you have to introduce. The meanwhile, what happened? He was transferred to Sikkim. So that out of sight, out of mind. This. Sikkim people protested. We are not garbage house of India. This. Generally, we have found that जब कोई जज कंट्रोवर्शियल हो जाता है तो उसको नॉर्थ ईस्ट में पोस्ट कर देते हैं. So that is our reaction anyhow, right? Finally, removal resolution is considered, he is found guilty, but he also resigns. Right? Resigned, not a punishment. तो अच्छा है सब लोग. Pooja Singhal also resigns as IAS. Isn't it? Anyhow, S.N. Shukla, अभी recent case था, that is called Uttar Pradesh High Court, Allahabad High Court. Right. और इसका हेडलाइन दिखाता हूं मैं. Right. सो एस.एन. शुक्ला से अब इसीलिए बोलते हैं ना कि भाई अगर मिस अप्रोप्रिएशन करना ही है तो 2400 करोड़ क्या करो यार. 2.4 करोड़ क्या होता है. तो दिल्ली में एक फ्लैट भी नहीं मिलेगा. Basically, it is a case since 2017, and Supreme Court has referred him for removal, but resolution has not been brought. This is the The case was pending since 2017. Supreme Court recommended 2 times to the government to remove him through resolution, but government did not bring. Ultimately, he resigns. Because CBI inquiry is, let's say, conducted like this. Then he also resigned. This. So this is another case, you'll find this. Then, before coming to mother of all cases, right, there was another case, same Uttar Pradesh related, name I am forgetting, इतने सारे नाम होता है कि how many names you should remember, in which another judge of High Court and one judge of Odisha High Court, 2 judges were involved basically. That was related to, I think, Sharda Medical Trust. Sharda Medical Trust is a medical college in Uttar Pradesh. One bench of Allahabad High Court de-recognized Sharda Medical Trust. After some time, the Sharda Medical Trust bribed judges so that they can recognize, and another bench after some time recognizes Sharda Medical Trust. That was the case. There are cases where judges have been alleged for corruption. Right? And this is how to tell the most, let's say that important you can consider, or mother of all cases you can say this. The Supreme Court, which laid down foundation for Visakha guideline, did not imagine that time that one day Visakha guideline will become, right, let's say that, gallows for them. This. They laid down Visakha guideline. Visakha guideline में चिल्ला के बोला है उन्होंने कि in internal complaint committee there should be one women member. Right. Now, they themselves do not have internal complaint committee. When there is allegation of one staffer, allegation of harassment against Chief Justice, right, then let's say first they try to suppress the allegation. Then suppression does not work. Then what they did, like this. They constituted first, if let's say that a meeting was called by Chief Justice of 5 judges, and he himself presided. The Chief Justice, who has been alleged, he himself presides a 5-judge meeting, and the 5-judge meeting decides an inquiry panel. And that inquiry panel did not have initially any women member. After media report, media ने criticize किया, then women member was included. and the inquiry panel submits report to the 5 judges again, which is presided by Chief Justice. Right. What logic he gave is that there is a big conspiracy against him, so he is trying to protect. तो वो तो किसी के अगेंस्ट भी होगा. मान लो कोई सीईओ कंपनी का है, उसके अगेंस्ट एलिगेशन है, तो वो भी बोलेगा कि हमारे अगेंस्ट बिग कंस्पिरेसी है. Right. Anyhow, women appeared only once before the panel, inquiry panel. As they bombarded with legal technical questions, she could not understand. She could not manage. Therefore, she requested that there should be a legal counsel. She should be allowed to represent herself in the panel through her legal counsel. But she was not allowed. Hence, only on one appearance, the inquiry panel came to the conclusion that there was no substance. Drug का कोई substance नहीं था. So, there was no substance in the case. And the report is submitted to 5 members presided by Chief Justice, and Chief Justice is acquitted. That is how it is. So you can judge yourself. Is it accountability? Right. First, it is violation of natural justice. Second thing is that don't you have trust in your other judicial members? Why you are presiding? क्या इतना सिचुएशन बुरा है कि जजेज में 34 जजेज में किसी भी जज में आपको ट्रस्ट नहीं है? Why not a senior judge, senior most judge after him should preside the 5 judges? Or why not a full court meeting called? All 34 judges meeting called. In that it should be decided. Why not, let's say 5 judge, let's say body in which you are not member, that should decide inquiry panel and report should be submitted. और जब ये सारा चल रहा था तो पार्लियामेंट वाले क्या कर रहे थे? राइट. वो क्या कर रहे थे? म्यूट स्पेक्टेटर. Constitution has given power to Parliament to uphold accountability of judiciary. But Parliament becomes here patriarchal. This is how patriarchy is reflected. Since it is a case related to women, तो इसको ध्यान देने की जरूरत नहीं है. राइट. और वो भी एक लोअर लेवल की स्टाफ है. राइट. तो इसको ध्यान देने की जरूरत नहीं है. जस्टिस की जरूरत नहीं है. तो पार्लियामेंट प्लेज ए वेरी म्यूट रोल. This you can say that. Or he did not bring removal resolution. Who has stopped? तो उन्होंने एक excuse दिया. Since there is an informal inquiry system in judiciary, they cannot bring removal resolution. वही इनका informal 1917 वाला. Right. वो तो informal है. Let them conduct inquiry. You bring your resolution to remove. And you don't remove that judge. Let there be fair inquiry. Why there should not be a fair inquiry? Are we afraid of a fair inquiry? Does it mean that the Chief Justice does not have faith even in Parliament? क्या वो इतना बड़ा, let's say that he considers himself? क्या जुडिशरी को उन्हीं को डिफेंड करना है कि पार्लियामेंट भी डिफेंड करेगा? तो ये जो कंस्पिरेसी थियरी है ना, ये समझ में नहीं आता है. Right. And that is how that justice is not delivered and judicial accountability is not upheld. This you can see this. That is how you can see here. So if we have problem of independence of judiciary, similarly we have also problem of accountability of judiciary. That has also suffered, let's say that, because time and again there have been allegations against judges, and in those allegations accountability has not been upheld. even if judges are found guilty. Right. He should have not been punished, but at least the basic thing was that there should be a fair inquiry by Parliament. The House should have constituted an inquiry panel consisting of any senior most judge, another judge of High Court, a jurist, and let them inquire. This. And if they did not find any substance, the matter ends there. This. So, but we do not conduct. This is how the problem that has been highlighted. That's why there are views that we need to bring change in a removal process, accountability mechanism, so that we can also improve standards of accountability if we are protecting independence. Many a time, this is how criticism, judiciary has fought for its independence at the cost of accountability.